Hey there, estate planning attorney Paul Rabalais, and in this video we're going to talk about whether payments that a parent makes to their adult child during the parent's lifetime whether that's actually an advance on that child's inheritance. Okay, so here's the deal. It's real common for parents to fork over money to their adult children because they want to enable their adult children perhaps to get out of debt or pay student loans or get out of some tax liability. Parents are giving money to their children all the time to buy a car, make a down payment on a home the child wants to buy. Parents are giving money to enable their children to take vacations. The list of things that parents throw money at their adult children for is endless. But when a child dies and that parent had forked over a considerable sum to one child and not to the other child or children, sometimes the you-know-what hits the fan. So let me give an example. Let's just take a simple example. Let's say mom, during her lifetime, she has two children. She gives Spencer the spender $200,000 over mom's lifetime. You know, Spencer needs the money. He doesn't do a good job saving money. His wife she's a spender. So mom, for various things that Spencer mom wound up forking over $200,000 to Spencer. But mom didn't give any money to her daughter, whose name happens to be Sally the Saver. Sally's frugal. Sally watches her money. And so mom never really had a need to give any money to Sally because Sally was really responsible with her money. And then when mom dies, of course, and it's time to settle the estate, and mom's estate planning documents, if she has some, says, I want to leave my estate to my two children equally. That makes sense. Then Sally the Saver says, whoa, time out here. Mom gave Spencer $200,000 because he couldn't handle his money. Mom, during her lifetime, never gave me any money. So I want to make sure I get the first $200,000 off the top from mom's estate, and then we'll split the rest. That sounds fair to me. All right, so what happens? Well, here's the deal. First, you have to determine whether those payments that mom made to Spencer the spender while mom was alive were a gift or a loan. Here's how you determine whether it was a gift or a loan. If mom had, this is kind of obvious, if mom had filed a gift tax return, IRS Form 709, that would have been required if mom had given Spencer more than $15,000, at least that's the 2020 number, in any kind of calendar year, then obviously it would have been deemed a gift. And if mom had Spencer sign a note, mom writes a check to Spencer for $50,000. Spencer signs a note. I promise to pay it back under the following terms. Yeah, and it's a loan. But as in most cases, mom didn't either. She just wrote checks to Spencer and did no further documentation. So why does it matter whether it's a gift or a loan? Well, if those $200,000 of payments to Spencer from mom were considered a gift, and mom's estate when mom dies is to be divided equally, then the $1 million estate that mom had, if that's what she had when she died, goes $500,000 to Spencer the spender and $500,000 to Sally. Spencer got extra because he got the extra $200,000 during his lifetime. However, if those payments to Spencer the spender during mom's lifetime are considered a loan, then Spencer's got to pay that back to mom's estate. And then the estate gets divided equally. Practically, Spencer probably wouldn't pay it back. He would just get less to reflect what he would have had to have paid back had those payments to Spencer been a loan. What happens most of the time? Most of the time, those payments that are made to adult children don't get documented either as a gift or a loan. The presumption is that if a parent writes a check to a child, an adult child, and there's no further documentation, I think the presumption is that it's a gift. And then if the will or trust of the parent just leaves the estate equally to the children, then the child who received the gift is really going to come out ahead in the long run. Spencer the spender will come out ahead in the long run because he got $200,000 from mom while mom was alive. Sally got zip. And then when mom died with her $1 million estate that she left to her children equally, Spencer and Sally each got $500,000 of that. And the likely result of that is Sally the saver will forever hold a grudge against her brother, Spencer the spender, because of the way Sally says he manipulated mom into giving him money. So what should you do? So a couple of things that are real important that you should do. One is you should hit the like button, because that tells YouTube to show my videos to more people. We can help more people. And then also, you want to hit the notification, the subscribe button if you haven't already, and the notification bell. That way you don't miss anything in the future. In addition to that, what should you do? Well, if your payment to your adult child is, if you want it to be considered a gift, and you want it, it's pretty easy to document the gift, because I think the presumption is that it is a gift. But if you want to count it as an advance on that child's inheritance, then your estate planning documents need to clearly reflect that. Those estate documents may say, I gave $200,000 to Spencer during my lifetime. I want that to be considered as part of his inheritance. So when I pass away, I would like Sally to receive $200,000 off the top, and then Sally and Spencer can divide the remainder of my estate. Something to that effect. So now, I will say most parents, especially when they just kind of occasionally help a child when that child needs it, they don't want to mess with that. They're like, no, most parents say, when our children needed something, we were happy to help them, and we don't want to keep track of all of that. Let's just keep it simple when we die. Whatever we have left when we die, let's divide it up equally. Let's not force them to go back into account for everything that we did for our children during our lifetime. So most parents feel like, just as they do stuff, it shouldn't count as an advance on the inheritance. But some do, and the records clearly need to reflect that. Now, if you want that payment to your child to be considered to be a loan, or quote, an advance on the inheritance that they'd have to be paid back to your estate or take less, then you need to document that payment as a loan. So your child likely needs to sign a note where they promise to pay it back to you or your estate. And then maybe you, if you want to, you could forgive that loan if you wanted to forgive it in your estate planning documents. And so lots of different options there for you to work through as you set things up, so that there's not all this difficulty when you pass away, and things are, according to you, fair. Children don't hold grudges against each other. So the key here is making sure everything gets documented properly. I'm Paul Rabalais. Make sure you smash the like button. We'll see you next time. Have a great day.